Hello and welcome to Mujibur Rahman Creations. In this video, I am going to discuss sources of Muslim law for LLB, BALLB and UPSC Aspirants. So generally speaking, before understanding sources of Muslim law, you have to know the concept of source. What is source? Generally, source means a thing or anything from which something originates, any place or anything from which something originates. So, the sources of Muslim law can be categorized into two parts. First one is primary source and then secondary sources. The primary sources of Muslim law are the Quran, the Sunnah and Hadees, the ijma or consensus of opinion, and then the qiyas or analogical deduction. Then the secondary sources of Muslim law are the urf or custom, legislations, precedent or judicial decisions, and then legislations. So this was the brief description or introduction to the sources of Muslim law. Now in your final exam of LLB, BLLB and UPSC, if you take law as an optional subject, you have to describe this. What are the sources of Muslim law? Give a detailed account or description of the sources. So now I am here to describe all these sources. Firstly, I shall describe the primary source, the Quran. Now, what is Quran as a source of Muslim law? You may have some questions. Describe Quran as a paramount authority of Muslim law. So you have to describe the Quran. What is Quran? The word Quran is derived from the Arabic word Qurra, Q-U-R-R-A, Qurra, which means to read. So the word Quran is derived from the Arabic word Qurra, which means to read. Quran is the permanent paramount authority of the Muslim law. It contains total 114 chapters and 6,666 verses. It contains 114 chapters and 6,666 verses. The chapters of Quran are known as surah, and then the verses of Quran are known as ayat. Now, Quran is revealed to Prophet Muhammad by Allah through angel Jibril Islam. It was given to him within a period of 23 years. 23 years period. Now, Quran, the sum of the chapters of Surah was revealed him in Makkah and some of them were revealed in Medina. So, Quran as a paramount authority or source of Muslim law, it contains 4 types of contents. So, the contents of Quran are divided into 4 categories. They are, number 1 is metaphysical. Number 2 is theological. Number 3, logical, ethical and mystical. And number 4 is rituals and legal. Now, if you are writing about Quran as a source of Muslim law, you have to write the word Quran is derived from the Arabic word Qurra, which means to read. It contains total 114 chapters and 6,666 verses. Most of the verses were revealed in Makkah and Medina. And then it is a divine revelation to the Prophet Muhammad from Allah through angel Jibril. Now, what are the contents? If you write it as a source, so there should be some contents. It is divided, the content is divided into metaphysical, theological, ethical and mystical, and then rituals and legal. Quran is over. And then now moving to source number 2, primary source number 2, Sunnah and Hadees. What is meant by Sunnah and Hadees? Now, moving to Sunnat. The word Sunnat is derived from the Arabic word Sunnah. Arabic word is Sunnah. So it is derived from the Arabic word Sunnah, which means to follow, which means and includes to follow the traditions of Prophet Muhammad. The traditions which were followed by Prophet Muhammad, if we follow this, it is called as Sunnat. Now, Sunnat is divided into four categories. Three categories. Number one is Sunnat ul Fail. Number two, Sunnat ul Qawl. Number three is Sunnat ul Taqrir. Sunnatul Fail, Sunnatul Qawl and Sunnatul Taqrir, these are the types of Sunnat. So what is meant by Sunnatul Fail? Sunnatul Fail means the traditions which were done by Prophet Muhammad. And then Sunnatul Qawl. Fail means to do. Fail in Arabic word, this is Arabic word fail, it means to do. So this is the traditions which were done by Prophet Muhammad practically. And then Sunnatul Qawl includes the traditions which were said or spoken by Prophet Muhammad. And then Sunnatul Taqrir includes those traditions which were done in the presence of Prophet Muhammad without his disapproval. So these are the types of Sunnat. And then moving to Hadees. What is meant by Hadees? The word Hadees is derived from the Arabic term Hadees or Haddasa. Haddasa. This is the Arabic term Haddasa. It means to describe something. Hadees, it means to describe something. And then they are also divided into three categories. Hadees is also divided into three categories. Hadees Mutawatir, Hadees Mutawatir. Number two is Hadees Mashhur, and then number three is Hadees Ahad. Ahad. Now, what is meant by Hadees Mutawatir? Hadees Mutawatir consists of what are followed by all the Muslims. It contains those traditions which are followed by all the Muslims without any exceptions. Hadees Mutawatir. Now, Hadees Mashhur. A Hadees Mashhur consists of those traditions which are followed by majority of Muslims but not by all. Majority of the Muslims follows Hadees Mashhur, but all the Muslims do not follow Hadees Mashhur. Moving to Hadees Ahad, it consists of those traditions which are followed by a particular Muslim family or Muslim people living in a particular locality. So these are the types of Sunnat and Ahadis. Now, moving to source number 3, Ijma. What is meant by Ijma or consensus of opinion? Ijma. Ijma is the third primary source of Muslim law. It means consensus of opinion among the jurists of Islamic law. The essentials of Ijma, a valid Ijma, are an Ijma will be said as valid Ijma if it follows this particular following rules. Number one is the Ijma can be made by jurists. So Islamic jurists or Islamic legal persons should make these ijmas. Number two is the jurist must be a Muslim, and then it should belong to a particular period of time. So the essentials of a valid ijma are: the ijma can be made by jurist. A Muslim legal person can make an ijma, and then the jurist must be Muslim, because a non-Muslim cannot discuss the provisions or the rules of Islamic law, Muhammadan law. And then number three is it should belong to a particular period of time, because if you make a law in this time, it should be modified in the later period, because the law does not exist in its same position after centuries, so it should be modified. Therefore, the ijma must belong to a particular period of time. Next, what are the types of ijma? Ijma can be divided into three types. They are ijma by jurist, then ijma by people, ijma by followers of Muhammadan law. So these are the types of ijma: ijma by jurist, ijma by people, and ijma by the followers of Muhammadan law. So this was a detailed description about ijma. Moving on to next point, qiyas. Qiyas or analogical deduction. This is the last and primary source of Muslim law. Qiyas means analogical deduction. In qiyas, the decisions are made by the reading of Quran. Sunnah and Hadees as well as ijma are read while making the qiyas. For example, any fatwa by any mufti is regarded as qiyas. Now moving on to secondary sources of Muslim law. What are the secondary sources of Muslim law? I have already given the list. So secondary sources. Number one is urf or custom. If you say about urf or custom, it means those traditions which are followed in the time of the Prophet Muhammad in Mecca or Medina. So earlier, initially custom was not regarded to be a source of Muslim law. Generally, custom was included in the list of secondary sources of Muslim law. Now there are something essentials to be a valid custom. A custom or urf would be said as a valid custom if it follows those following points. What are they? Number one is it must prevail in a country. Number two is it must be territorial. It must be territorial. Number three is it must exist from the time of Prophet Muhammad, and then it must be ancient and invariable. It must be ancient and invariable. Last point is it should not be opposed to any morality or public policy. So custom are the rules or traditions followed by the followers of Prophet Muhammad from his time. So there are something essential there. Number one is custom must prevail in a country. Next, it must be territorial. Next, it must exist from the time of the Prophet Muhammad. Number four is it must be ancient and invariable. And last point is it should not be opposed to morality or public policy. Now moving on, next point, judicial precedent or decisions. Judicial decisions as a secondary sources of Muslim law. It means the decided cases. In India, the decision of the Supreme Court shall be binding upon the subordinate courts, including the high courts also. So, the decisions made in the Supreme Court regarding any question of law or any question which has arisen regarding the Muslim law, it should be followed by the subordinate courts. So, it is called as judicial decisions. Then, point number 3, legislations. Legislations are the third secondary source of Muslim law. In India, the Muslims are governed by certain legislations. These legislations led to certain changes in the Muslim law, present Mohammedan law. So, these legislations are very important. Number 1, the Sharia Act 1937. Number 2 is the Special Marriage Act 1954. The Special Marriage Act 1954. Number 3 is the Child Marriage Restraint Act 1929. The Child Marriage Restraint Act 1929, and then the Indian Contract Act 1872. Indian Contract Act 1872. So these are the legislations by which Muslims are governed in India. The Sharia Act 1937, the Special Marriage Act 1954, the Child Marriage Restraint Act 1929, and the Indian Contract Act 1872. So these are the sources of Muslim law. Legislations can be said as sources of Muslim law in India. So these legislations cover as the secondary source of Muslim law. Moving on to last source, secondary source of Muslim law. It is equity, justice, and good conscience. Number 4 is equity, justice, and good conscience. If there is no law on a particular matter of or question of law, then it should be decided on the provisions relating to or on the principles of equity, justice, and good conscience. The jurist shall hear both the parties, take all evidence, and decide the matter by applying the principle of natural justice. It is essential that the jurist must be learned and must have skill in learning. He should be a Muslim jurist. So, while deciding the cases or conflict between two Muslims, if there is no existing laws regarding that matter, then it should be solved, or it can be solved by applying the principles of equity, justice, and good conscience. So, in the conclusion, you can add that. So, by studying or by analyzing these sources of Muslim law, you can say that it is affected by certain legislations now. But talking about the primary sources, it cannot be amended so easily, but the secondary sources can be amended easily, and these are affected by the legislations. So this was a brief description analysis about the sources of Muslim law. To get any videos regarding law paper, Muslim law, Hindu law, law of contract, and any law, subscribe to my channel, share with your friends, and please like the video. So thanks for watching this. I have already made certain questions regarding the very important questions for a final exam of BA, LLB, LLB, and UPSC. So you can get this inside my channel, and I shall regularly upload the videos relating to the important questions of law for LLB, BA, LLB, and UPSC aspirants. So to get these videos, subscribe to my channel, share with your friends, and hit the bell icon to get notifications. Thanks for watching the video today. Have a great day. Thank you.